Hello and welcome to another video in our video series, 3 Minutes of California Family Law, brought to you by Family Law San Diego. I'm Bud Kluig, founding and managing partner of Family Law San Diego. Today we're going to talk about language in talking to your attorneys. There's a problem when judges and attorneys try to talk to people who are not judges or attorneys. Let's call them normal people, probably most of the people viewing this video. One problem is jargon, which is fancy professional words that lawyers and judges use. It's important that if you don't understand a term, please get your lawyer's attention and have them explain it to you, and don't stop until you do understand it. But there's another problem, that the legal profession snags onto normal English words and use them in a very particular way. A good example is the word permanent. There is, in the area of restraining orders, the issuing of domestic violence temporary restraining orders. And the law requires that there will be a hearing regarding a permanent restraining order within 25 days. And then you get to that hearing and the judge says, I'm going to issue a permanent restraining order for 5 years. Now, how can it be permanent if it's for 5 years? But of course, in legal terminology, the use permanent is to differentiate or make it different than the temporary restraining order. It is not permanent in the ordinary sense of the word, but it is permanent as opposed to temporary. There's a similar problem with terminology in the divorce setting. Divorces in California take at least 6 months, most of them substantially longer. A typical divorce is 9 or 10 months. It's not unusual to take more than a year. And if you have children, things have to happen in the meantime. They have to get picked up at school, soccer practice. They need to be supported. And so the judge, during the pendency of the case, while the case is ongoing, will issue temporary orders regarding child custody, child visitation, and child support. At the end of the case, in your final decree of divorce, there will be, again, permanent orders. But those orders can be modified for support, including alimony, child support, child custody, child visitation. The orders can be modified, even though they're permanent orders, anytime there's a change in circumstances. If this sounds complex and confusing, to a certain extent it is, please ask your attorney whenever you don't understand some terminology or some use of the word. We at Family Law San Diego are very intent on having our clients understand the terminology and the words at all times. If you have further questions about the language that lawyers and judges use, or the difference between temporary restraining orders or court orders and permanent court orders, please contact us at Family Law San Diego. Our phone number is 619-448-6500. Stated slightly differently, 619-448-6500. Or visit us on the web at www.familylawsandiego.com. That's www.familylawsandiego, one word, no dots, no dashes, .com. Thank you for watching another video in our video series, 3 Minutes of California Family Law, brought to you by Family Law San Diego.